Physicians face challenges every day, from difficult patient encounters to changing regulatory requirements. At Copic, our commitment to you goes beyond providing reliable medical liability insurance. What sets us apart is our proactive approach, a 24/7 hotline answered by physicians, specialty-specific guidance and CME-accredited education, and unwavering dedication to help you thrive. COPIC.com. We're Copic, here for the humans of healthcare, here for you.
You can't just blindly accept what the AI tool has told you to do. You have to make sure that you protect yourself from liability.
Welcome to Off the Chart, a business and medicine podcast featuring lively and informative conversations with healthcare experts, opinion leaders, and practicing physicians about the challenges facing doctors and medical practices. My name is Austin Littrell. I'm the Associate Editor of Medical Economics, and I'd like to thank you for joining us today. In today's episode, at Medical Economics Senior Editor Richard Payerchin sat down with Christopher Mayer, a specialist in employment law with the firm Frier Levitt. They're talking about how artificial intelligence is reshaping workforce decisions, from algorithms quietly driving layoffs at major companies to the compliance risks the practices may face when AI tools have too much influence. Christopher Mayer, thank you for joining us, and now let's get into the episode.
Thank you for joining us today.
Thank you, Richard, and happy to talk about AI and its usage in layoffs, which is the topic today. It's obviously a very timely topic. We're seeing more and more, everyone, how AI is impacting both the workforce and industry in general. So I think it's an important topic, and for your audience, I think they will appreciate what we have to discuss today.
Absolutely, and it's a great introduction because we'll start sort of big picture and then we'll drill down into healthcare a little bit, because there already have been some employment actions involving decisions around AI, artificial intelligence, that have taken place. Can you describe the current workplace or workforce situation around adoption of artificial intelligence and businesses laying off employees, especially how they're maybe using artificial intelligence to guide human resources decisions?
Absolutely, yeah. We're seeing it we're starting to all see it on two fronts, really. And the first front is that AI, generative AI primarily, is now being used by employers to make employment-related decisions. So they will feed their workforce factors into AI and try to determine, using AI and the algorithms in AI, determine who should be eliminated, what jobs are redundant, can be replaced. So we're seeing that, obviously more and more, and a lot of that's going on behind the scenes, but it does leak out from companies, that have used AI for these purposes. And Verizon's kind of a recent example. We can talk about that. Verizon did about 13,000 layoffs recently, and they didn't really cite AI as part of it, but it kind of leaked out that AI was in some ways behind the scenes in some way. And the other thing that we're seeing, in addition to the use of AI to make employment-related decisions, layoff decisions, is that AI is obviously disrupting workforces across all industries. And we'll talk about healthcare, but it doesn't matter what the industry is, really. Every industry is going to be impacted, it appears, by AI in some way. And that is resulting in some redundancies, elimination of jobs are being considered. And, there's a lot of fear out there, obviously. None of us understand fully what AI means for the future. And I think that includes the people who are developing these AI tools and are investing so much in it. We don't fully know where it's going, and no one knows fully, whether or not their jobs are going to be impacted by it. And I think, in the tech industry in particular, I think, when AI first started coming out and the rumors about it, I think coders and other people in the tech industry just assumed that they were going to be a big part of it and their jobs were safe forever. And that's not how it's played out. I mean, AI, as it turns out, is making a lot of those coding type jobs completely irrelevant or unnecessary, because AI can do it faster, better. There needs to be some human element still in terms of programming it or plugging in the information, but a lot of those jobs are going by the wayside. So it's hard to really predict the impact completely. But the good thing for healthcare is one of the industries that is primarily, or for the most part, immune from a huge impact of AI replacing jobs. I mean, obviously, healthcare is a patient-facing industry, and humans will always be a big part of that, and that's not going to change.
And it's a great segue just to drill down a little bit, maybe a little bit more on healthcare. At least as of right now, February 2026, have there been any major AI related layoffs across the healthcare sector?
That's a great question. There haven't been many public ones. I mean, what we're seeing more like the Amazons of the world, where the Amazon recently, starting in October last year, eliminated 30,000 jobs, and those were good, high-paying jobs, kind of across the board. And they specifically said that this was AI driven. It says we're integrating and adopting AI tools in our business. We're going that route. There haven't been a lot of prominent examples in healthcare, and part of that is because I think that the layoffs will be smaller. And if you're talking about a small provider, which I know is a lot of the audience here, they're never going to be covered by, say, the federal or state WARN Act. So they're not going to have to report a layoff to a provider, or to the state, or to the folks that have to be notified under the WARN Act, because their layoffs just aren't going to be covered by it. And a lot of those providers just aren't covered by the WARN Act to begin with. What we're going to see more of, I think, is with larger health systems when they're making reductions. And that's kind of the most prominent one that we've seen so far out in Utah, a health system, Revere Health, I believe is the name of it. They eliminated almost 200 jobs, nearly 7% of its entire workforce. And that was a largely AI driven layoff. It was a lot of coders and other folks that, are expected to start to lose their jobs in the AI world.
Well, no, it's an interesting point that I think you touched on just a few moments ago, and it's sort of that dichotomy that takes place in healthcare, where you have hands-on work, where you're actually working with patients, but then there's also, frankly, a lot of head work that involves, physicians and other clinicians getting the education, the training experience to recognize conditions. And I'm just kind of wondering, I mean, we're already seeing how AI is being used as a tool to supplement that head work, so to speak.
Yeah, and I think for small providers, you're not necessarily going to see a lot of public results and layoffs and things like that. What is going to happen is it's going to be more behind the scenes. And I think small providers may benefit more from the transition into the AI world as much as anyone. We're seeing that with, say, Anthropic and other generative AI companies. When they go in, they target an industry, whether, and more recently, I think it was ChatGPT did this in the investment banking world. They created a training run, as they call it, to basically replace junior investment bankers. And so, as these companies focus on what they can do and what they can replace, they're making a lot of existing software tools, or eventually they're expected to, and that's why we're seeing a huge impact on the software industry in general, obsolete. They'll be able to provide similar, maybe even superior software tools at a much reduced cost. And I think a small provider could certainly benefit from that. But what I'm seeing is that small providers are also early adopters of AI usage just in their general life. And I think that's in part because if you're a physician running a small practice, it's just like anyone who runs a small business. You got to do everything. You may have accounting people, you may have finance people, but you're hands on and you've got to be in that. And so I'm seeing those folks doing a lot of the outside work, a lot of the administrative work using AI. And it doesn't mean they're accepting it as as a panacea, or that the answers that they're getting from AI they're accepting as accurate always. I think they're just starting to adopt it and use it to make research things and make some decisions.
A great segue to start talking about that intersection and that moment of making decisions regarding human resources. Can you talk about, and maybe this is still very new, but what is exactly the intersection between human resources and employment law and AI? There are, I know, different points that are going to sort of exist under that umbrella of human resources and employment law. But what are some trends that you're seeing, or what would you predict?
Well, I mean, certainly any sort of service facing industry or business, they have to carefully address and regulate how their employees use AI. So that a lot of that's going on in terms of adopting policies. But I do think, in healthcare in particular, there's going to be an impact on, as we talked about, folks who do coding, claims. Like there's going to be a huge impact on that, and that's where I think AI is really going to come into play over time and start to affect it. But from the HR perspective, that what HR people have to be mindful of when they're doing a large scale reduction in force. And for a small provider, a large scale reduction is, 3 or 4 employees. It doesn't have to be 50, 60 employees. But the main thing they're going to have to be mindful of, just like you have to be mindful of in any reduction, this is no different than any other reduction that you're doing, is the impact that it's going to have across protected categories. So what that means is you still have to make sure before you go through with a layoff, and if you're using an AI tool to tell you who should be eliminated, you're going to have to sit down carefully. And sometimes this should be done through counsel, so you can, have the attorney-client privilege attached to it, but that's kind of another matter. But look at the impact that it's going to have. And if it's going to, the layoffs that AI say is suggested that you do, if it's going to eliminate, 5 or 6 people over the age of 40 and no one under the age of 40, that's not a good look, and that's a problem. And that not only is that a problem in terms of potential liability, but if you're going to do a reduction where you're trying to get a release in exchange for a severance, which is a very good business practice and something that any sophisticated employer does, you're going to have to disclose the ages of the people who are impacted by the layoffs and the ages of the people who are not impacted by the layoffs under federal law to get that release. So the Age Discrimination and Employment Act, which is the federal law I'm talking about, it sets forth very particular requirements for a reduction in force that impacts really more than one employee, a group of employees. And that is one of the things that you have to do. You have to show who by age, you don't have to identify them by name, but by job title and by age, is being impacted. And so if you're seen as an employer a disparate impact, the employees who are being impacted by that are going to see it too. And not only that, you have to tell them they should go and consult with a lawyer before signing the agreement. So they're going to take that lawyer's going to look at that and go, don't sign it. We might be able to sue over this if they're going to go forward with it. So that's a long way of saying, you just have to be very mindful of the impact, and that it's not limited to age. I mean, obviously any category that's protected by law, race, gender, all the the protected categories, you have to make sure you're looking at it and determining whether or not it's going to have a disparate impact on your workforce. And if it is, and statistically it doesn't look good, and there are tools that you can plug that data into that will tell you whether it's going to have an improper statistical impact, you might have to make adjustments to the layoff. This analysis is more appropriate, as you can imagine, for a large-scale layoff. Whereas, in a large-scale layoff, if there's a statistical anomaly, that's a problem. So any sort of statistical anomaly would be sorted out in a large-scale layoff. Like if you're doing 5 people and 3 happen to be over the age of 40, well, then there may not be much you can do. That's a little different. But if you're doing a large scale layoff and there's a huge impact on one protected category, that's a problem. I mean, it really is. So, but even in a small layoff, you just have to be mindful of the impact it's going to have, who's going to be affected by it. You can't just blindly accept what the AI tool has told you to do. You have to make sure that you protect yourself from liability.
You know what? And this was a point, I don't mean to belabor the point about age, but I guess I just wanted to ask if you might lend even a little bit more clarity toward the notion of, if an employer is not allowed to ask a person's age when they apply for a job to avoid discrimination, how are they able to avoid potential liability when you're making a layoff if you're not totally sure of a person's age?
That's a good question. And so employers do have access to the information. They have access to the birth dates of their employees. And most employers have to do annual EEO reporting, so it requires them to gather some of that information, although a lot of the information Folks don't have to provide it. It's optional, like race and, things like that. So you don't always have all the information. Age is one that employers do tend to have all of it. So, you do know the ages of your workforce just because on certain pre-employment and early employment documentation, you have to disclose your age. But other categories, you don't necessarily know it. So in that instance, it can be a problem. So what you have to do when you're doing a layoff, and if it's a large number of employees, you put together what's called like an employee census. So you're going to prepare a chart of everybody that's included in the layoff by name, by job title, by compensation. You do all those things. And those things are sometimes behind the scenes as factors. But then whatever statistical information you have about them, whether it's race, national origin, you fill out those categories. If somebody's out on a disability leave, you check that box and you put it all in there. And that's important so that you can see it all together. But if you don't know it, you leave it blank. You can sometimes try to guess, but that's, not always a good, a good system, as you can imagine. But it is important to gather that information together. And then you want to see the people who are not being impacted by it. So, if you're looking at a job criteria and you're trying to eliminate it, half of the people in that job category, and you've picked half, whether they're poor performers or what have you, you got to see who is staying by the same criteria. You need to compare it and see. And that you can present to an attorney or, a consultant who will crunch the numbers on that too, if it's too many people involved. If it's a smaller scale, I think an employer can do that themselves.
And this is something that wanted to ask about sort of two different elements, because sometimes in fact, medical economics, frankly, we cover a lot of policy at the federal level, and there are certain federal rules, especially regarding, discrimination, that govern employment law. Can you talk about any kind of federal bills, initiatives, policies that are in place right now that affect how AI is used in employment law and human resources?
Not at the federal level, really. So most of what we're seeing is going on at the state level. The current administration. So, for example, the EOC, one of their initiatives that they were tasked with looking at was reverse discrimination. So they're kind of focused on things that they traditionally have not been that focused on. And at least from what I'm seeing, the administration is more of a proponent of AI, and so they're not seeking necessarily to regulate it yet. And that's obviously an issue with AI in general. It's largely unregulated. So there's there will eventually probably be more regulation, but right now there's not a lot. But where we are seeing attempts to regulate AI in terms of its impact in the employment world is at the state level. And California, as usual, is one of the states that, kind of has jumped out. They adopted some regulations that just, kind of regulate how AI is used in hiring, firing decisions. Just that they want to know if employers are using it and, how it basically says you can't discriminate in that process, which is obvious. And, in terms of the other laws still apply to an employer equally, but they're just focusing in on AI to try to, make employers more mindful of it. But now, not at the federal level, not much that I'm aware of, no.
And I think you've touched on this in some of your answers just by implication, but this one I'll ask you to sort of look into the crystal ball, so to speak. And can you make any predictions about potential litigation or enforcement trends that might involve artificial intelligence in employment law and human resources?
I do think there will be challenges, and again, I'm primarily coming at this from the employment world, but I do think there will be challenges to employers who are using AI to make employment decisions. And again, that isn't always widely known. I mean, these decisions, when they're made, are done in secret and often are done, with counsel. So, but it does tend to leak out. So I think employees often find out if an employer is using a tool because there is some level of management involved in it, and they may share that with other folks. And so what will happen if there are these types of challenges to it? It'll be very important if they're not putting a lot of information into a public AI tool. I mean, that will be very important. Like you can't be putting private information into a public AI tool. Information that's protected as private health information, obviously in the medical industry, medical world, that's extremely important. But if there are challenges to that, they'll be interesting because they'll be largely based on speculation. In other words, you won't be able to find out until you sue, and you're saying that there's some sort of bias built into whatever tool that they're using, and that's to me that's the main concern. I mean, we have seen that some AI tools have inherent biases built into them because of how they're programmed, and we saw that with Musk tool with Grok, and we've seen that with some of the others, and those they can go in different directions, and without getting political about it, they obviously they can have bias, and it really depends on the information that's fed into the AI tool or that it has access to. So that that is one concern, but the bigger concern is what we already touched upon. Like, and this could be individual claims, it could be class action, multi-plaintiff employment actions, where there's a disparate impact. So some sort of challenge to a large, typically large, could be from the EOC, but more likely from a private lawsuit to an AI related layoff that seems to have had a disparate impact on a certain category of folks. And that's inevitable. I think that's going to happen. And obviously we touched upon ways to avoid being the target of that type of lawsuit. Just be careful, be mindful of it. But it will happen. It always does. And there are challenges already regularly to layoffs for having a disparate impact. And I think it'll be very interesting when those first cases come along, because we talked about the fear and the misinformation. So putting a case like that before a jury, I don't know how. I have an idea of how a jury generally might act. I don't think they're going to be happy with it. I think jurors will not like it, and so that would be a huge problem. And they're just going to assume that the employer really had a pretext and wanted to discriminate and is trying to hide behind AI to justify it. I think that's how jurors will. And jurors are very straightforward and honest about these things, and they like to punish employers who want to run astray, in a sense.
Hey there, Keith Reynolds here, and welcome to the P2 Management Minute. In just 60 seconds, we deliver proven, real-world tactics you can plug into your practice today, whether that means speeding up check-in, lifting staff morale, or nudging patient satisfaction north. No theory, no fluff, just the kind of guidance that fits between appointments and moves the needle before lunch. But the best ideas don't all come from our newsroom. They come from you. Got a clever workflow hack, an employee engagement win, or a lesson learned the hard way? I want to feature it. Shoot me an email at kreynolds@mjhlifesciences.com with your topic, a quick outline, or even a smartphone clip. We'll handle the rest and get your insights in front of your peers nationwide. Let's make every minute count together. Thanks for watching, and I'll see you in the next P2 Management Minute.
If I may switch gears slightly,
Sure.
One of the items that I know you've written about in the past has been non-compete agreements used, especially in healthcare and medicine.
Yeah.
Earlier this year, the Federal Trade Commission made clear its attitude toward enforcing non-compete agreements. How would you describe the current atmosphere around federal enforcement and particularly non-competes for physicians and other clinicians?
Well, yeah, we saw the FTC a few years back try to aggressively regulate non-competes, and there were a lot of questions on whether the FTC even had any jurisdiction over that. I personally believe they did not have jurisdiction over that, but they were trying to assert their jurisdiction broadly, and that was shot down in Texas. And that rule that the FTC had adopted was shot down by a Texas court and joined, so it's no longer in effect. So where we are right now, the federal at the federal level, non-competes really aren't regulated. Like when I deal with or look at non-competes, I'm primarily concerned with state law because that's what matters. So, and in every state, it's completely different. I mean, so you have to, where employers who have multi-state functions or practices run into trouble is when they have one non-compete agreement for, all employees, and they try to use it in every state, and that just doesn't work. I mean, non-competes are only appropriate, first of all, for certain types of employees. I mean, a low-level employee should never be bound in general should not be bound by a non-compete unless they have access to some sort of special information, and which suggests that they may not be that low level, right? If they're, doing something like that. And, you have to have non-competes. You have to be mindful that there are different laws depending on the position that you're talking about too. So physicians, if we're going to focus on physicians, there is seemingly a trend nationally to move away from non-competes with physicians, but in most states they're still enforceable. So and when you're running a medical practice and you start to get larger, a non-compete is a very effective tool to have to protect your investment. You're hiring physicians, whether you're hiring a young physician or an experienced physician where you're paying this physician a lot of money to bring them over. It's an investment, and so they do protect your investment. No one wants to spend a lot of money in training and providing other tools to physicians just to see them take that investment and jump to another employer a couple years later. So they are effective to protect those investments. But again, you have to be mindful of what state you're operating in, and there are a few different levels. Like California is obviously the classic example. They ban non-competes. There is no non-compete that is enforceable in the state of California. So that you start with that proposition. That's a statute. There are other states where they're regulating certain industries. Pennsylvania is an example. Pennsylvania last year adopted a statute that really limits what you can do with a physician in a non-compete. So first of all, it has to be limited, and this is only for non-competes going forward. This didn't apply to old agreements, but in Pennsylvania, a physician cannot be bound by a non-compete that's longer than 1 year. And if an employer fires a physician, it's unenforceable. You can't enforce it. It's only if the physician leaves on his or her own accord. In other words, if they resign, maybe you can enforce it, but otherwise you can't. And then there are other states where there aren't statutory schemes, like say New Jersey or New York, but non-competes are generally enforceable against physicians under certain limitations. They need to be very narrow, whether it's a year or two, no longer. In New Jersey, for example, a large geographic restriction is not generally enforceable, especially in urban areas. It needs to be tight. It needs to be, say 15 or 20 miles and no more than that. So that's with non-competes, it's very important to be, if you want to have one that's potentially enforceable, and they're never guaranteed to be enforceable to begin with, because they always depend on the circumstances, and there's a human element, which is the judge who's enforcing it. So even if there's not a statute prohibiting it, a judge might be favorable to enforcing non-competes or not. I mean, so there's a lot that goes into play. But if you want any chance that it's potentially enforceable and to act as a deterrent, which is where I think they're the most valuable, you need to make sure it's compliant with whatever law of the state where you're operating, that or where the physician is based. That's the critical consideration. So, just having one non-compete that you think you can use forever, it doesn't work. It really doesn't.
And just to continue on that train of thought, in from an employer's perspective, I know there's a lot of debate under the healthcare umbrella, so to speak, about the benefits and drawbacks of non-competes regarding especially physicians who may be young in their careers or physicians who are considering changing employment. If they sit down at that negotiating table and the hospital or healthcare system or another group of managing physicians presents to them a non-compete agreement, what should they do?
Well, this is going to sound very self-serving, but I think they need to consult with an attorney. And, for a variety of reasons, I mean, we just touched upon it. The law in different states is completely different. And a local practitioner in particular will know the ins and outs of how, they're enforceable in that state, may have appeared in courts recently where the relevant courts where they can tell you where the judges are on enforcing non-competes against physicians. So you need to get legal advice for sure before you sign it. I would say, don't jump into it. Don't be pressured to sign a non-compete before you talk to an attorney. And, you may learn that, well, maybe it's not enforceable. So sometimes you can tell the employer, well, why are you asking me to do this? It's illegal in the state, or even though they're asking you to sign it, it's illegal in the state and you don't necessarily need to be worried about it going forward. So those considerations come into play. But also, if you have a non-compete in place already and you signed it 15 years ago, in particular, the law may have changed. So if you're going to leave an employer to go somewhere else, get legal advice. Again, the law may have changed, or an attorney can negotiate with your new employer. The new employer can take a look at your existing non-compete and make a decision on how to bring you over that doesn't violate the non-compete, so you can work outside of the restricted area if the employer is large enough. And your attorney may be able to get some protection for you in the contract in terms of being indemnified and protected if you are sued individually by your former employer. So you think you're doing nothing wrong, but that doesn't mean your former employer isn't going to make assumptions that you are violating the non-compete and come after you. And if that's the case, you want to make sure that you're protected by your new employer who wanted you to come over, knew about the non-compete. You want them to, not leave you high and dry in the event of litigation and to protect you.
That point about particularly a physician notifying a new employer, that's an interesting nuance. And I don't think frankly, I don't think we've really covered that angle at all. So I'm glad you brought up that point, because that was a new one to me. And the prospect of getting a new employer to sort of lend that aid, that sounds like that could be a helpful tool for physicians.
It is. And the worst thing you can do when you're leaving and you're bound by a non-compete is to lie to your former employer deceive your former employer about what you're planning to do. Oh, no, I'm not going to work, and then go somewhere else. That's when you get into trouble. And the same thing with your new employer. Don't, if they ask you the question, obviously you have to disclose that you have a non-compete, but don't hide it. Let your new employer know, I got this restriction. I'm worried about it. What do you want me to do? And first let their legal team opine on it, look at it, offer their opinion. I still think it's important to potentially have, depending on the circumstances, have your own separate counsel in that situation, as we talked about. But, let their legal team look at it. Don't hide it from your new employer, though. You don't want to do that.
One question I always do like to ask, though, our main audience is primary care physicians.
Yes.
What would you like to say to them, or what would you like them to know?
Oh, well, that's a good question. I mean, I hadn't thought about that, but in terms of AI, I would say to them, don't be fearful of AI. It's, there's a lot of misinformation. There's a lot of assumptions that it's going to be more harmful than do good. And we don't totally know, but I think for physicians in particular, it's going to supplement the care that they can provide, some of these AI tools. And I think a lot of physicians are already finding that to be the case. And I think hopefully it, over time will be viewed as more of a positive. Now, I'm not saying that from someone who is on the inside of AI in any way. I tend to be optimistic, and I hope it will be a useful tool for folks over time, and it won't necessarily result in the widespread decimation of jobs that we all seem to fear right now.
I'm Richard Payerchin, reporting for Medical Economics. My guest today has been attorney Christopher S. Mayer, a specialist in employment law with the firm Frier Levitt. It's been a great conversation, and we've covered a lot of ground. Thank you so much for joining us today.
Thank you, Richard. It was a great conversation, as you said, and I look forward to speaking with you more in the future.
Once again, that was Christopher Mayer, a specialist in employment law with the firm Frier Levitt, speaking with Medical Economics Senior Editor Richard Payerchin. On behalf of the whole medical economics and physicians practice teams, I'd like to thank you for listening to the show and ask that you please subscribe so you don't miss the next episode. As always, be sure to check back on Monday and Thursday mornings for the latest conversations with experts sharing strategies, stories, and solutions for your practice. You can find us by searching Off the Chart wherever you get your podcasts. And if you'd like the best stories that medical economics and physicians practice publish delivered straight to your email 6 days of the week, subscribe to our newsletters at medicaleconomics.com and physicianspractice.com. Off the Chart, a business and medicine podcast, is executive produced by Chris Mazzolini and Keith Reynolds and produced by Austin Littrell. Medical economics and physicians practice are both members of the MJH Life Sciences family. Thank you.